The email came in at 11:47 p.m. No meeting notice, no vote reminder, no discussion. Just a message stating that the HOA had updated community rules, effective immediately. By morning, everything had changed. What was allowed yesterday was suddenly prohibited. Homeowners were told to comply or face fines. No grace period, no warning, just instant enforcement. At first, most people assumed it was legitimate. After all, HOAs can change rules, right? But when I read the fine print carefully, I noticed something they clearly hadn't. One small legal detail, and that tiny oversight meant the new rules weren't just unfair. They weren't enforceable at all. Up until that night, the neighborhood had been predictable. The HOA wasn't perfect, but it followed a routine. Proposed changes were announced weeks in advance. Meetings were held. Votes were recorded. Whether people agreed or not, at least the process felt familiar. That's why the midnight email stood out. It wasn't framed as a proposal. It wasn't labeled as pending approval. It read like a final decision. The board had amended community regulations, and the changes were effective immediately. By sunrise, enforcement had already begun. The new rules targeted several things at once: parking arrangements, exterior fixtures, even minor property uses that had been permitted for years. Some homeowners woke up to notices on their doors. Others received warnings attached to the email thread. There had been no meeting, no vote announcement, no opportunity for comment, just a statement that the board had acted within its authority. Most neighbors didn't question it. When something looks official and arrives from the HOA's official address, people assume the process was handled properly behind the scenes. But something about the timing bothered me. HOA governing documents usually outline exactly how rules can be changed: notice requirements, quorum percentages, homeowner voting thresholds. Those aren't suggestions. They're procedural safeguards. I pulled out the association's bylaws and started reading. That's when I realized the issue wasn't what the new rules said. It was how they had been adopted. And the more I compared the email to the governing documents, the more obvious it became that something critical had been skipped. Not accidentally overlooked. Skipped. Once the rules went live, the consequences spread fast. Neighbors started comparing notes. One had received a parking violation for something that had been allowed for years. Another was told a structure on their property was suddenly out of compliance, even though it had been approved long ago. Fines were being issued as if the rules had always existed. When homeowners pushed back, the response was the same every time. The board had authority. The changes were valid. Compliance was mandatory. Anyone who questioned the process was told they could address concerns later, after the rules were enforced. That phrasing alone raised red flags. HOAs don't usually punish first and explain later, unless they're trying to create momentum before anyone checks their work. I kept digging. The bylaws were clear. Any rule change affecting homeowner use of property required advance notice, a formal meeting, and a recorded vote. In some cases, it even required homeowner approval. None of that had happened. I asked for the meeting minutes. There weren't any. I asked when the vote took place. The response was vague. Something about board consensus and emergency authority. But there was no emergency, no safety issue, no urgent threat that justified bypassing procedure. Meanwhile, enforcement escalated. Second notices arrived. Fine amounts increased. The language became sharper, more urgent, more absolute. The HOA was moving quickly, as if speed itself would make the rules real. That's when I noticed something else. The new rules weren't just inconvenient, they benefited the board. Restrictions aligned neatly with personal preferences certain members had complained about in the past. It felt less like governance and more like power being exercised while no one was looking. I sent one final email asking a simple question. Under which section of the bylaws were these changes adopted? The reply didn't answer it. Instead, it warned that continued noncompliance could result in further action. That was the moment the situation shifted. Because when authority refuses to cite its source, it usually means it doesn't have one. And the tiny legal detail they'd skipped wasn't buried or obscure. It was the foundation holding the entire rule change together. I stopped arguing in emails. Instead, I sent one certified letter. In it, I cited the exact bylaw section outlining how rule amendments must be adopted: written notice to homeowners, a scheduled meeting, quorum requirements, and a recorded vote entered into official minutes. I asked for proof that those steps had been followed. This time, the response wasn't confident. It was defensive. The HOA president replied that the board had acted under administrative authority. That phrase sounded official, but it didn't exist anywhere in the governing documents. There was no clause allowing the board to rewrite restrictions overnight without procedure. So I escalated, but not emotionally. I requested access to the association's records, something homeowners are legally entitled to. I specifically asked for meeting minutes approving the new rules. There were none, because there had been no meeting. That's when the tiny legal detail became unavoidable. Under state HOA law, any rule change adopted without proper notice and vote is void. Not questionable, not debatable, void. When I shared that with a few neighbors, the reaction was immediate. People who had already paid fines realized they might not have owed anything at all. Others began requesting refunds. The board suddenly found itself answering not one homeowner, but several. Within days, another email went out. It stated that the recently announced rule amendments were being temporarily suspended pending procedural review. Enforcement would pause. Fines would not be pursued. The board would revisit the matter at a properly noticed meeting. There was no apology, but the tone had changed completely, because once the legal foundation was exposed as missing, the authority built on top of it collapsed on its own. A few weeks later, the HOA held a properly noticed meeting. This time, the email went out in advance. The proposed rule changes were attached. A date, time, and location were listed clearly. It looked the way it should have from the beginning. Attendance was higher than usual. Homeowners asked questions. Some challenged the substance of the changes. Others focused on the process. The board couldn't rush it. They couldn't enforce first and justify later. Everything had to be discussed openly. When the vote finally took place, several of the most restrictive rules didn't pass. The ones that did were modified. And most importantly, everyone could see how it happened. The fines that had been issued under the overnight update were quietly reversed. Accounts were adjusted. Notices disappeared from doors. What had felt sudden and absolute only weeks earlier was now acknowledged as premature. The board never admitted they'd skipped procedure. They didn't have to, because once homeowners understood the bylaws, the power dynamic shifted. Authority didn't vanish, but it became accountable. That was the real takeaway. HOAs can change rules. They can enforce standards. They can govern communities. But they can't ignore the process that gives them that authority in the first place. And sometimes the smallest legal detail isn't small at all. It's the line between enforcement and overreach.